construction of statutes. And this time I will try to project and discuss in front of you the big picture. I'll try to compare developments in the civil law and in the common law traditions. And the question that we'll have here, you've seen a number of parallels in the previous discussion. Can we bridge the divide between the common law and the civil law? Would a bridge make sense? Let's see. The civil law and the common law traditions have both moved to an age of statute and rapid legislative change. Legislative change in the civil law can be in updating the civil codes, which give you the general law, but also developing tons of additional statutes or additional codes. And in the common law, we have seen that all legislation is special. All these statutes can be regarded as special law, and they tend to pile up and populate the compilation or codes that organize the matter alphabetically or by topics. So you can really compare the legislative development in the civil law and the common law world. Another thing that the systems share in common is that both traditions share some maxims of interpretation or canons of interpretation, as we tend to call them in the common law world. I just give you here a few examples that pop up in interpretation on either side of the civil law common law divide. Inclusio unius est exclusio alterius. The fact that you include something in an enumeration means that you exclude all the others that are different. Eius dem generis rule. When you have an open list, it's the sort, and if you have a catch-all, you will open it to all things of the same kind. And we live, by the way, in the civil law and the common law with the possible contradiction between these two canons of interpretation, and have to check whether the list is a closed list or an open list to know whether you have to use the first one or the second one. You have also the noscito sociis. You tend to define an ambiguous term by reference to those that resemble and may be found in other parts of the statute. We prefer to say in peri materia in the civil law world, but that's the same idea, okay? So yes, you have a number of tools. You know, you'll find hammers and screwdrivers in the common law toolbox and in the civil law toolbox. But does that mean that because we are at an age of statute everywhere, all over the place, and share a few canons of interpretation, that we should conclude that don't look for difference, Professor Moreteau, don't make our life more complicated, focus on what is the same? No, I'm sorry, some significant differences remain, and you need to visualize and understand these differences to make the optimal use of the rules of interpretation in one system or in the other. And as we will see, these differences are background related. When we talk interpretation, we should not focus only on the text to be interpreted, but we always must have in mind the context, what is existing around here. So the importance of the background, all common law statutes compared to special laws in the civil jurisdiction, and that is very important. Always keep in mind that when you say a statute in the United States, outside Louisiana, but even in Louisiana, when you look at the revised statutes, there's a special provision, the fact-driven and case-driven position. And though codes exist in the US, those codes, as have seen in the earlier video, are not systematic arrangements like codes in the civil law world. Matters are arranged by the alphabet or by topic, and nobody expects that they cover all problems and be comprehensive. Oftentimes, you do not find the solution to your case in the statute, I insist. So the key question is, what law does apply when the statute is silent? And here I'm going to put in perspective the response of the civil law and the response of the common law tradition. Because the problem occurs on both sides of the dividing line. In the civil law, when a special law is silent, I mean a special code or special legislation, you go back to the general law. The general law controls. And that means that you're going to try to work out a solution from the civil code, which supposedly contains the general law. And in those very rare cases where you don't find anything there, you have a rule to fill the gaps. So, as a consequence, in a civil law tradition, special laws, more technical laws, are strictly interpreted because they derogate to the general law. Okay, we accept that the special laws apply because the case is within the scope of the special law, but don't overstretch or try to expand the scope of the special law because it is very often making a solution different from what you have in the civil code. So, courts in continental Europe or Latin America, or they should also do this in Louisiana, should not overstretch special laws and go back and work out the solution from the general law, namely the civil code. What do we have on the common law tradition? When the statute is silent and the statute is special law, case law controls, as I said earlier. You go back to the cases and you work out a solution from the cases. The common law is the general law. And as a consequence, statutes tend to be strictly interpreted because they derogate to the common law. So the predominant view, but this in the common law tradition, it applies to every statute. You rather go with a strict or restrictive interpretation. The only exception to this may be the Constitution, because it's written in general terms, okay? It is also a sort of general law of its kind. So when you look at this, you start understanding that whenever you are dealing with special technical legislation all over the place in the civil law world and in the common law world, the strict interpretation tends to prevail, and you go back to a general law, civil code in the civil law tradition, common law, or the Constitution as interpreted by the courts, also largely speaking common law in the common law tradition. Back to the bridge. So one may safely compare the interpretation of special laws in the civil law tradition and statutes. Both are detailed and specific. They tend to be strictly interpreted because they make exception to the general law, civil code, or to the common law, case law, okay? But I come now to the general law. The interpretation of the civil code is a different world, because it is systematic and comprehensive. The moment we go to code interpretation, you apply the methods that we have discussed in module 6, exegesis or the modern method, because you are there in the realm of general law. And when you are in the common law world, the common law is judge-made. It's not subject to interpretation. You don't do the exegesis of a case. I'm sorry, that doesn't make sense. But you work with the particular techniques that have developed in the stare decisis world, you know, looking at distinctions, overrulings, etc. What we have discussed in module 8. So I think now you start having a map, okay, what's going on here. Whenever you're dealing with special legislation, wherever you are, civil law, common law, strict interpretation prevails. But when you go back to the general law, then you're getting different worlds. You're getting into the world of the civil code, exegesis, génie, modern methods, if you are in a civil law tradition, or you go back to the common law and the way you engineer it if you are on the common law side. Look, you have here, I've tried to make this more visual. In the civil law world, the general law is to be found in the civil code. It applies by default, and it is interpreting using exegesis or modern method. Its special law is what you find in specialized codes, or ancillary statutes. It derogates to the general law and therefore receives a restrictive interpretation because exceptions are to be interpreted restrictively. That's one of the maxims of interpretation, okay? So you have the visual on the civil law side. And as you may expect, I created a similar visual on the common law side. There it is. The common law, the general law, is called a common law, and it is case law, whether it is, by the way, common law or equity. Okay, we are using here common law in the sense of case law. It also applies by default, and the tool to handle the cases are all the techniques that we have studied when discussing stare decisis. And you have statutory law, which is special law, okay, whether it is codified or not, whether it's found in separate statutes or in compilation. It derogates to the general law, it derogates to the common law, and therefore is also receiving a restrictive interpretation. Okay, take a deep breath. I have a few more visuals. And again, like with all videos, if you don't get it the first time, it's no waste to looking at the video a second time. I have here another visual that points to points of convergence and points of divergence regarding civil law and common law. The left is the civil law side, and the right is the common law side, okay? If you look at the interpretation of special law on the left side, or interpretation of statutes, that's where we identify the convergence with a predominantly restrictive interpretation, maybe more textualism than you would expect otherwise. But things diverge, and you have a big difference between common law and civil law when you are discussing code interpretation, I mean civil code interpretation with exegesis and modern method, okay? Or where you are on the general side, also on the common law side with stare decisis. It's very difficult to make parallels between exegesis and method, you know, of stare decisis. Don't try. Leave that to experts if they want to venture in this largely uncharted territory. I hope these visuals will help you. If you are, you know, if this one is problematic for you, look at the others, and of course, send questions my way. I will always be delighted to answer. So we come now to the end of this discussion of statutory law, and I could not miss this opportunity as we come to the end of the second big block after having discussed the civil law and the common law. Somehow we needed to put them in parallel. Merci, thank you for your attention, and see you next time with other exciting topics there's still plenty in stock.